Hi everyone, welcome to our video. I guess all of us have already seen the fake versions of our favorite product. Like for Nike, we have seen the name of Mike or Neck. But do you know that is illegal based on the laws of identical trademarks? So today, let's find out about that together. First, let's go through a short overview of trademark. According to Weibo, a trademark is a sign capable of distinguish the goods or services of one enterprise from those of other enterprise. Trademarks are protected by the intellectual property rights. For example, the trademark Nike identifies the shoes made by Nike and distinguishes them from the shoes made by other companies. For example, like Reebok or Adidas. Similarly, the trademark Coca-Cola distinguishes the brown-colored soda water of one particular manufacturer from the brown-colored soda of another, like Pepsi. When such marks are used to identify service, for example, Jiffy Lube, rather than products, they are called service marks, although they are generally treated just as the same as trademarks. The symbols TM, which is the trademark symbol, and the R with the circle outside, which is the registered trademark symbol, can be used to indicate trademarks. The latter is only for use by the owner of a trademark that has been registered. In many cases, a trademark that is identical with an existing one will not be able to register and will not receive protection from the country laws. So what is an identical trademark? An identical trademark is classified as any mark that is a reproduction of any already registered trademarks. For a trademark to be deemed as an identical trademark if it is exactly the same compared to a control mark in terms of structure, content, meaning, and form of expression. According to point B, Clause 39.8, Article 39 of Circular in January 2007, a control mark can be understood as trademarks registered for protections or recognized for protection in Vietnam, including well-known trademarks, or trademark application filed earlier or with an earlier priority date, or trademark applications that have expired but have not been older than 5 years. For example, trademark Hua have been registered by CNTP Limited Company for protection of electric cables and some electrical equipment in Group 09 and granted a trademark registration certificate by the NOIP in 2005, and in 2006, SV Electric Cable Company applied for registrations of trademark Hua for electrical cable products and electrical equipment in Group 09. This trademark was refused by VN National Office of IP for registrations on the basis that it was identical with trademark Hua, which was previously issued to CNTP Limited Company. So now we know about identical trademarks, but what about identical and similar goods and services? Two goods and two services shall be considered identical if they have the same nature, like compositions, ingredients, and the same functions and utility, or they have similar natures and the same function and utility. Two goods or two services may be considered similar if they are similar in nature, or they are similar in function or utility, and they are marketed in the same commercial channel. They are distributed by the same mode or sold together, or compete with each other in the same type of shop. A goods or a service may be considered similar if they have a correlation in nature. A goods or service or a material or component of a goods or service forms constitute part of the other, or they have a correlation in function. To accomplish the functions of a goods or service, it is necessary to use the other, or they are usually used together, or they have a close correlation in method of realization. A goods or services is the result of the use or exploitation of the other. In many cases, we easily can distinguish two similar trademarks, but sometimes it could be really hard to tell. These cases can be considered confusing similarity. The IB law states that a mark is considered to be confusingly similar to a control mark if and only if the following two conditions are met. First, the mark is similar to the control mark in terms of structure, content, pronunciations, and meaning, or form of expression. At the same time, products and services may be similar to reference product and services. The second condition is the sign is so close that it makes the consumer mistakenly believe that the two objects are one, or that one object is a variant of the other, or that the two objects have the same origins. According to point C, clause 39.8 circular in January 2007 by TTCP, amendments and supplements in 2016.
So what are the factors for identifying trademark likelihood of confusion?
First, relatedness of goods or service.
This answer for the question, are the two marks of the same product or service? For example, Coca-Cola and Pepsi are the same product type, carbonated soft drink. Secondly, similarity in appearance. Marks can also be too similar and confusing when it comes to their appearance and design. For example, like Adidas and Adidas. Third, there will be similarity in sound. Similarity in sounds refers to the phonetic match between marks. For example, like Cody and Cody. And finally, similarity in meaning. Among the important factors influencing likelihood of confusion is the mark's meaning in relation to the goods and service descriptions. For example, like Red Sun and Mặt Trời Đỏ. D. Vietnam's laws regarding. According to Decree 105/2006 NDCP, which was amended and supplemented by the Decree 119/2010 NDCP, an infringing elements to a trademark may be in the following forms: using a sign which is identical to a registered trademark, and the goods or service are also identical. In this case, the products bearing the sign shall be considered as counterfeit. At present, with modern printing techniques, there are many fake products launched into the market, and it is difficult for consumers to distinguish the genuine goods from the counterfeit one. Second, using a sign which is identical to a registered trademark, and the goods or service are similar. This case rarely happen. However, there have been some cases handled. For example, the trademark Trường Sinh registered for sweetened condensed milk, powder milk of the foremost company was used to attach package of soy milk products by another enterprise. This case was judged through two instances. First instance, hearing by Hanoi People's Court, and appellate hearing by the Supreme People's Court, with the final conclusion that soy milk was similar to sweetened condensed milk, and the use of the sign Trường Sinh for soy milk is an act infringing upon the trademark Trường Sinh for foremost company. Third, using a sign which is identical or similar to a registered trademark, and the goods or service are different. This case can only be handled when the violated trademark was recognized as a famous trademark by the court or National Office of Intellectual Property, and the such sign may make customers confused about the origin of products or service, or fair impression about the relationship between the manufacturer or trader of the product or service and the owner of the famous trademark. Finally, using a sign which is similar to a registered trademark, and the goods or service are identical. This is the most popular form of trademark infringement, commonly known as the production and the consumption of counterfeit goods. It can be seen that any kind of products bearing reputation trademarks or popular with the customers are all imitated. Omo soap and Levy mineral water are the typical examples for the trademark infringement case in this category. The third part is case of confusing similarities. Now let's jump into some case of confusing similarity. Here we have two trademarks, McDonald's and McDowell's. First, about the design, we can see a similar idea with the big M logo in a similar color. For the name, McDonald's and McDowell's are quite similar, especially the letter S and the Mc, which are two signatures of McDonald's. And both of their products and services are fast food and beverage. Finally, when we spell the name of these two marks, we can see that two of three syllables are the same. After considering the above factors, we can easily see that these two trademarks can make it easy for customers to confuse. Thus, we can conclude that McDowell's had the element that is confusingly similar with the control mark of McDonald's. Therefore, it will not be protected under the intellectual property laws. Now, let's move on to the second case between Highland Coffee and Highlight Coffee. All of us already know about the Highland Coffee, right? Highland is a well-known coffee brand not only in Vietnam, but also in the international market. First, regarding the trademark design, we can see that they are similar in the shape and frame. The letters are even in the same fonts. About the name of trademark, Highlight and Highland can easily confuse us with the same word, high. About products and service, both of them are beverage. In terms of sound when pronouncing it, 3 of 4 syllables are similar, so we could not even tell the difference if we pronouncing it fastly. After considering the above factors, we can easily see that Highlight Coffee is creating confusing similarity on purpose for commercial use, so it will not be protected under the intellectual property law. That's all our videos about identical mark. Hope you can enjoy it.